Welcome to another episode of P.I.E for Thought by ijpiel. Today we're with Ms. Devina Srivastava. We're going to be talking about construction development sector, how we as law students can become a part of it, how we can do better in the sector, how Devina ma'am has worked in the sector, and finally, what changes can be introduced, how you can pursue a further LLM based on this and the experience that you get from this. So I'm Chaitanya, I'm a part of the podcast team, and we have
Hi, I'm Abeer. I'm Associate Editor at ijpiel.
so now before we dive into the questions, Abeer is going to give a small introduction on the construction development sector. So basically a summary for the uninitiated who don't have any idea about it. We don't want you to be clueless during this podcast. So a small idea and a context for you to consider.
Right. Thank you so much, Chaitanya. Now, when we talk about Indian infrastructure sector is rather an interesting sector which contributes heavily to the Indian economy. Now, even if we look into the contribution made by the Indian infrastructure sector, even with the 100% FDI limit that has been put by the government of India, there is a worrisome gap because the service sector and the Indian IT sector, when we talk of them, they are giving or they're contributing much more to the Indian economy in comparison to the infrastructure sector. Now, this is something which is a question of concern because, again, because of the 100% FDI limit that has been already put through. That is point one. And second is because the union government, both the union government and the state government, after COVID-19 recovery, they have been heavily relying on the Indian infrastructure sector, and especially that of the construction development sector, to stabilize the economy, which also includes a lot of cash inflows and inviting tenders both at the domestic level and at the international level. Hence, there are certain things that at the very same time the governments have put forth certain routes, that is exit point and entry points. That essentially is something that we are going to talk with Devina ma'am. It includes broadly, it includes 4 to 5 categories, and that is how we pursue Indian infrastructure sector. In specifics, the entry and exit routes of foreign investment with regards to the construction development sector. Over to you, Chaitanya.
So now you have some sort of a basic idea how the construction development sector is a pertinent area, especially in the context of COVID and the hindrances it created. So taking that into consideration, it's fairly important for the construction development sector to make more contributions when taken in relation to the service and IT sector, especially with the relaxations provided by the government. So taking this into context, we're going to try to figure out what's lacking, how the sector works, and accordingly, we're going to ask questions from Devina ma'am. But before we get into the meat of it, we do want to know something that most law students care about. What is the kind of work that goes into the law firms? I know we want to talk about the subjective aspect of it, but at the end of the day, if we do choose to become a lawyer in this specific subject, what does a law firm do? What do associates get? And like the kind of work that it entails. So Devina ma'am, if you could expand upon that.
Sure, Chaitanya. Thanks for the question and thanks for the very enlightening overview, Abeer. That actually sums up very aptly the relevance of the construction and development sector, which forms a sub part of the infrastructure sector. So just if I may shed a little more light on that before I get into what work law firms do in particular in relation to the construction development sector. So the infrastructure sector, if you look at infrastructure, it's defined as the building block of society, or we say it is any structure, whether physical or operational or facilities that are required for the operation of the society. So this could be anything. This could be a building, this could be railways, this could be airports or aviation, or an educational institution, or a hospital, telecommunications, broadcasting. So the list is endless. And therefore, the infrastructure sector is a very broad and very vast sector that carries a lot of significance for the economy. Now, when we talk about construction and development, I would say, is a subset of infrastructure. It is essentially the activity of constructing or developing certain aspects of the infrastructure sector. And these are defined under India's FDI policy, or foreign direct investment policy. And construction and development would cover your hotels, which is hospitality. It'll cover resorts. It'll cover roads, bridges, educational institution, residential and commercial premises. It will also cover your recreational facilities. So all of that comes under construction development. But if you notice, what I did not cover for construction development, but I covered for infrastructure, would be your telecommunications, aviation, railways, industrial parks. So therefore, construction development is sort of like a subset of infrastructure, which is a larger umbrella. And today we're going to focus on construction development because it forms a bulk of infrastructure, and it is categorized as a separate subsector under the FDI policy of India. So from foreign investment perspective, construction development carries a lot of significance. So coming to your question, which is what work do law firms do in relation to construction and development? So law firms deal with all legal aspects, everything, all kinds of legal services which may be required with respect to this sector. First of all, there are dedicated teams in law firms for projects, infrastructure, energy, which will help with all aspects of infrastructure, such as if there is, let's say, a public-private partnership. So right from the preparation of tender documents or bid documents for participating in such a partnership, to conducting the due diligence or structuring the financing of such a project, a law firm will be able to assist with all of that. In fact, there are also general corporate teams, M&A teams, and private equity teams that also help with all transactional aspects of a deal in this sector. So for instance, I worked with the general corporate team at a firm, and I was involved with one or two deals concerning the construction development sector. And our work spanned from right from the structuring of the transaction. That is, how is the money to be brought into this sector? Should it be in the form of debt? Should it be in the form of equity? Should it be a combination of both? Through which route should it be brought in? Right from those aspects to actually conducting the due diligence, which is where we try to identify any red flags with the project or with the investment and highlight them to our client, the investor, to actually drafting the documentation. This could be anything. This could be a joint venture agreement or a share purchase agreement or a business transfer agreement. So drafting the documentation, and finally the closing actions, where we look at everything that needs to be done to actually effect the sale or the transfer and complete the transaction.
That's a pretty wide scope of operation, picking it up right from the beginning, the nascency of the transaction, and taking it right till the end. And in particular, I found one thing interesting when you were differentiating infrastructure and construction development. It seemed like, I'm sure people do care about airports, railways, their services that are provided to us. But when it came to construction and development, it seemed like it was more related to public usage, daily public usage, stuff that we are, interacting with on a daily basis, like roads, bridges, and on a certain level, even hotels and resorts. So that I feel like forms a very, very important part of the infrastructure, especially considering the public interaction. So that is a very interesting view on it. But yeah, so next question, Abeer, you want to take that one?
Yep, I'll take that. Thank you. So, ma'am, I think you beautifully enumerated upon what or how the law firm works. But I think this could be, after hearing this answer, everyone's question would be, if they might get interested on the said topic, on how, as law students, can prepare to work in this particular sector for that matter, and especially law students belonging to certain universities जहाँ पे the subjects are of such nature where they don't teach you energy laws as such, because I don't think so that they focus specifically on certain sectors. I think there are just two three universities which teach energy laws. So how would you answer that?
Sure. So I think this is a very exciting sector. And if students want to get involved, there's a lot to study here. And as you said, unfortunately, our law schools may not actually have this as a specific subject, or may not be in a position to teach things relating to this area. So therefore, it's very important to have practical training as much as possible. I think whatever I learned about this sector was on the job itself. And so students may have an upper hand if they're able to, let's say, intern with firms or intern with teams that work in this area. Even if they're not able to intern themselves, maybe they can get in touch with experts in this area, people who work in this area, through probably conferences or reaching out to them and then discussing their ideas or discussing and learning from these experts who've been practicing in this area. So that's one kind of, outreach and learning from people. In addition to that, I think it's very important for students to be commercially aware, because this area is something which is changing constantly. A lot of new laws, new regulations, new rules are being implemented, and deals are being structured in very innovative ways these days. So again, it's very important to be commercially aware. For that, I think it might help to read newspapers such as Mint or the Business Standard on a daily basis, look at specific deals, specific transactions which have happened, and try to analyze them. Also look at what kind of changes the government is bringing in, and then go back to the laws and read the laws which are applicable to this sector. So those might be local laws, or those might be, maybe real estate laws, or other laws which are applicable, such as environmental laws, which are applicable to this sector, and understand the intent behind those laws, because it's only then that a person will be able to apply them. And I think one of the most important laws to understand, especially for transactional work in this space, are the foreign exchange laws in the country. Because foreign exchange laws, again, is something which is not typically taught in great detail, in great depth in law schools. So it might be very helpful to go through them to understand different ways in which foreign investment can be brought in different sectors, especially this sector, and then see how deals are being structured in light of these laws.
This answer really highlighted the dis disadvantages in the course structure that most of the law schools follow, right? And even like Abeer is in Pune University, I go to Jindal. Both of us like had a conversation about this. Most of our courses that follow, they are like a very base level. Okay, you studied property law, company law. We don't really delve into the intricacies of it, how that might affect. And even when it comes to electives, when we do want to specialize in something like that, most of us do not really have an elective which focuses on construction development or energy law for that matter. But yeah, so
Right.
continuing to the next question. But finally, we do get into the technical part of it now. So we would like, you mentioned the foreign investment aspect of it, how the Foreign Exchange Management Act and allied laws would be very important when it comes to construction development sector, and how students need to be well prepared with them in order to be effective in the sector. So regarding that, if you could provide us with an overview of the routes of foreign investment, which can be uh, pursued by various investment investors to make investment into the various projects that maybe are being undertaken in India.
Sure. So I think for any sector, there are three major routes which are applicable for bringing foreign investment into that sector in India. These may have further subcategories, which I'll touch upon, but broadly there are these three. One is FDI, or foreign direct investment. One is FPI, or foreign portfolio investment. And one is ECB, or external commercial borrowings. So foreign direct investment is essentially foreign investment in capital instruments of a company in India. Now, capital instrument means anything which is in the nature of equity. So it might be equity shares, it might be compulsorily convertible debentures, warrants. All of this will constitute capital instruments. Now, in FDI, what happens is that the foreign investor invests in these equity instruments, and therefore it sort of gets a say in the decision making of the company usually, because the stake in which the investor is invested is usually large. It's larger than 10% in most of the cases. And since this is in the nature of equity, what we see is that there are certain voting rights or certain decision making rights which flow to the foreign investor. So this is the basic characteristic of FDI. Now, FDI in the construction development sector, 100% FDI is allowed, which means that a foreign investor can acquire up to 100% of the share capital of a company engaged in this sector, or it can start its own company holding 100% in India. But of course, this is only for the construction development sector. For aviation, there might be different conditions which are applicable. For railways or mining or other things which form part of infrastructure, there may be other conditions. But for construction development, there's 100%. Another condition for FDI in construction development is that there is a lock-in period, which means that the foreign investor can sell its shareholding or exit the investment and repatriate its earnings only after a given period of time. This period of time is 3 years. And if it wants to exit this sector before 3 years, the trunk infrastructure needs to have been completed. Trunk infrastructure means the roads, the street lighting, sewage, drainage, the essentials of running a project should have been completed for the foreign investor to exit. So this is the first route. The second route that I spoke about is FPI, or foreign portfolio investment. Now, foreign portfolio investment is different from FDI because here, first of all, the foreign investor has to register itself with SEBI, or the Securities and Exchange Board of India. And the investment will happen mostly in listed securities. So these securities may be shares, warrants, debentures, which are listed on an Indian stock exchange. Or it might be units of mutual funds, collective investment schemes, or AIFs. In some cases, of course, it's possible for the securities to not be listed if they're in the nature of debt, but mostly the securities are listed. What we also see is that for FPI, the investment can only be up to 10% of the paid up equity capital of a company, or 10% of each round of issuance, each series of debentures, preference shares, or warrants. So therefore, there is that limitation of up to 10%. And so an FPI investor will only hold a minimal stake in a company, and it will not have as much of a lasting interest in the company as would an FDI investor. Right? So that's FPI investment. Under FPI, there's another route which has been introduced by the government called FPI VRR. VRR stands for Voluntary Retention Route. Now here, what the government is trying to do is that it's trying to encourage foreign investors, FPI investors, to retain their investments in India. So it is saying that if an FPI investor is willing to retain a certain minimum percentage of its investments, which they're calling the committed portfolio size, CPS, if it's willing to maintain that amount in India for a stipulated period of time, which is 3 years usually, it can be something different also as decided by RBI. So if the CPS is going to be maintained for the stipulated period of time, then the FPI investment will be free of various macro-prudential and other regulatory norms which are applicable, such as, otherwise, if an FPI investor was to invest, there is a minimum residual maturity period of 1 year. That is, any debt securities should expire or mature only after that 1 year period. This will not be applicable to FPI VRR investments. Similarly, only up to 50% of bond issuance can be made in favor of an FPI. But this is again not applicable for FPI VRR. There are concentration limits which are not applicable. So without getting into very technical stuff, it essentially is just that certain norms or regulatory norms are not applicable to FPI VRR. But I think I forgot to mention FPI VRR is only for debt securities. So through FPI VRR, equity investments can't be made. It's only when investment is in debt, such as debentures or bonds, it's only then that VRR can be utilized. And lastly, there is ECB, or external commercial borrowings, where, as the name suggests, the foreign investment is brought in the form of debt again. So it could be in the form of a loan, it could be in the form of investment in debentures or other kinds of bonds which are issued. This could be denominated in an Indian currency, INR, or it could be denominated in a foreign currency. And again, there are various rules and regulations that are applicable, such as the investee company needs to maintain a certain liabilities to equity ratio. Then only up to 750 million USD worth of ECB can be brought in. There's again a lock-in period of 3 years. So these are some of the conditions. But as you would have noticed, for FDI, there's a separate carve-out made for construction development. There are conditions applicable to this sector. But for FPI and VRR, there are no separate conditions sector-wise. These are general conditions which are applicable. But one thing which is quite important is that under FDI and under ECB, under both of these routes, investment is not permitted in the real estate sector. And then, the natural question that arises is, how is real estate different from construction and development? Because if you hear the two terms, it seems like, oh, they should be very similar. So that's very, that was very interesting to me also when I first heard of this. In fact, I got to hear of this when we were working on one of the transactions. And our client, the foreign investor, wanted to invest in a company that was sort of like a promoter and developer of projects in India. And they wanted to invest in debentures. But the question was that, will this be categorized as investment in real estate? Because if it's real estate, then they can't make the investment. It's a prohibited sector. And we wanted to take the view that this is not real estate, this is construction development. So we looked at the difference between the two. And the difference is that real estate is where the company is dealing with the purchase or sale of land or immovable property. So when there is dealing in immovable property, purchase or sale, it is then that they call it real estate. But if it's simple construction and development of structures on a particular piece of property or on properties, then it is simple construction development. So this is something which might be worth noting for students.
That was a very interesting differentiation.
Yeah.
I, for the most part of the podcast itself, thought that they're the same. But when you put the differentiation like that, it becomes quite simple. Abeer was wanted to comment something.
Yeah, I think the same. It's not just that. I think there is a difference when when there is a rental property and the rent accrued from that. And Devina ma'am and I had a conversation on the same as well. Ki ma'am, like, what the difference ki wo real estate property se jo rent aa raha hai, what to do with that? So ma'am then cleared that out. Ki no, that is also, that's FDI. They have their own issues. So, ma'am, going to the next question, when we look towards you highly spoke of the regulations. That essentially means that the government has placed a lot of regulations with respect to foreign investment in the construction development sector, which I think makes sense because, again, foreign exchange and all those things, when all the allied forces are they are making an impact, then regulations are important. So, ma'am, in your opinion, do you think that you can critique the FDI policy of the government at any point you think, be it the FDI or FPI or ECB policies that the government has put forth, that this could be a lacuna or a loophole that the foreign investor might undertake and leave the project dangling?
Yes, in fact, that's a very interesting question, Abeer. And here again, in my answer, I will touch upon the lease aspect and the rent aspect that you spoke about. So, under the FDI policy, as we were discussing, there's a lock-in period applicable of 3 years or development of trunk infrastructure. But what is trunk infrastructure? Trunk infrastructure is the backbone of the project, right? It's the roads, the lighting, the water, drainage, all of those things without which I don't think a project can function. So when we say that that a foreign investor can exit after 3 years or after development of trunk infrastructure, I think there is a problem. Because then, after 3 years, a foreign investor can exit even when the trunk infrastructure has not been developed. It can exit either after development of trunk infrastructure within the first 3 years, or after 3 years, it can exit at any point with or without development of trunk infrastructure. So I think that is an issue. And I think that completion of the trunk infrastructure should be a condition to the exit of the foreign investor. The other thing that is a problem is that the definition of real estate is not the same, is not symmetrical across all of these different regulations. Under FDI policy, it states that real estate is simply buying or selling of land or immovable property, and it does not cover those things which are covered by construction development. And then recently, there's been an amendment to the FDI policy, which says that earning of any rent income or leasing of property does not constitute real estate. So, if a company is engaged in renting or leasing of property, it can raise foreign investment under the construction development sector because this activity would not constitute real estate. But under the ECB policy, the case is different. Under ECB, they say that even if you're leasing property and earning rent income, it is still real estate. So then ECB investments are barred if a company is engaged in such activities. So I think that there should be some, and there are obviously other minor differences also, but this is a major one that sort of I thought was very noticeable. And so I think that there is need to make the definitions congruent across all foreign investment regulations, because the intent at the end of the day is to regulate foreign investment and to bring in foreign investment, whether it be in the form of debt or equity, FDI, FPI, ECB. So I don't see a reason for the definitions to vary across these instruments. And of course, in general, other than this, other than from a foreign investment perspective, there could be other things that can be done. Construction development in general has not been very attractive a sector, because a lot of times there are delays in completion of projects, and then things go to NCLT, which takes its own time again. And even though there are prescribed timelines, these are not always adhered to. So maybe to make this sector more attractive, more conducive, there could be attempts made to ensure that there's speedy resolution of disputes, especially insolvency disputes, and maybe more flexible and more innovative resolution plans are encouraged. So these are some of the things that can be done. The government could also enter into more public-private partnerships to encourage investment in this sector, and I think then that would be a major step in the direction of ensuring foreign investment.
That is a great overview on the same, especially upon the speedy resolution aspect of it. We have seen how the CIRP process specifically, though it's not related to this, the 90 days and the 180 days extension, the thing that they have, it has really assisted in making the process much faster than required. Sorry, much as fast as it is required. And the same can be applied across various sectors, especially construction development, given that the delays are very prevalent in this sector. Like, even when you like, most of my friends or anyone who has ever purchased a house, or if their parents have purchased a house, you can see how in every single case there is always a delay. And if not, there is some shoddy construction or some shortcuts that they've taken. So this is something that should be addressed, and you covered that pretty well. Abeer, did you want to add anything?
Yeah, I just had one question, since you were talking about, ma'am, establish a nexus between the IBC and the construction sector. So, ma'am, I think even Chaitanya touched upon the subject. Section 12, subsection 3, there's a proviso to it which talks about, to IBC, which talks about indefinite delay with regards to any proceedings which have been invoked under IBC. And we all know that, as Chaitanya also mentioned, and even you mentioned, that there have been delays in construction development sector, like a lot, especially when we talk about the third party delays in the construction development sector. So, ma'am, how do you think a nexus could be established with regards to the delay in the construction sector? Would that defeat the section 12 subsection 3's proviso of IBC, or how should it go, like, please?
So the thing is that I'm not an expert on IBC itself. So I won't be able to comment on, whether it will qualify under the proviso or not, or what should be done under IBC. But generally speaking, I feel like even when third parties are involved, or even when there are, inordinate delays without actually the promoter or the developer being at fault, there is need to take strict and urgent action. It can't be that, we've all seen projects where the promoter or the developer will always have reasons that it's COVID, so because of COVID there is a dearth of funds, or there are lockdowns because of which the project can't be completed. Or he'll say that I have this supplier or I have this subsidiary company and it is not performing well, and it is not, let's say, complying with its contractual obligations, because of which the project is not being completed. So I don't think that a free hand should be given. And in any case, there are, in case of such kind of justifications or valid reasons, there is RERA that is able to provide extensions, and that is able to say that then the delay in completion of then the date for completion of the project can be extended to such and such a date. But under IBC, I feel like once an insolvency petition has been filed, very strict view should be taken of the reasons for delay. And if it is found that there have been lapses, or if prima facie there appears to be a case for insolvency, I believe that the CIRP uh, should be constituted immediately, and impending immediate action should be taken.
Mm. So for the next question, Abhi, do you have any follow-up regarding
No,
this?
no, no,
Okay,
please.
cool. So perfect. We'll move on to the next one. This is a very interesting one, specifically given the fact that the disinvestment started in 90s and it has been going at a very speedy pace. And so till this point, we have seen disinvestment in various sectors, and we have also witnessed disinvestment specifically in the construction development as well. So how this disinvestment has provided for private parties to enter, and how it has become fruitful, or if it hasn't, because at the end of the day, we are seeing some discrepancies and some issues that are arising. So if you could address those.
Sure. So, see, I think, yes, you're right in saying that this investment started in the early 90s with the National Economic Policy, where we started bringing foreign investment and we are allowing the dilution of the government's interest in various undertakings. But I think most recently, the government has introduced a very thorough and a very rigorous disinvestment policy, which is unlike any other policy which was introduced by the government in the past. And now they're looking at significant dilution, whether complete or partial of their stake in various public sector undertakings. And the idea is to monetize infrastructure and to raise funds for infrastructure. And this will help in easing the burden on the government, the fiscal burden, as well as ensuring a good and steady flow of finance and revenue for the government. So I think largely I think there are 23 or 24 projects which are being covered, and these go vary from domain to domain across the infrastructure sector. So there are projects for aviation, there are projects for tourism, there are projects for insurance. We've most recently seen the LIC IPO. There are projects for steel. So there are various undertakings which are being monetized. And I think this is going to have a very good and a very fruitful impact on the economy at large, and especially relevant for foreign investors who see these as opportunities to bring their investment into India. And along with that investment, along with the money itself, what we'll gain is in terms of the technical and the financial and the commercial expertise that come with such investment. So in that sense, I think it's a good idea and a good policy to engage in. And I think there are going to be issues, but I think those issues are arising from the policies that are in place, where we look at the foreign exchange laws, or we look at the other laws which are applicable to various sectors. And if those laws are not conducive to investment in themselves, then no matter what is on offer, a person may or may not be interested in investing. So as we touched upon the construction development sector, similarly, I think under various sectors, there are various things which need to probably be taken another look at, especially under the foreign investment laws, to ensure that there's a steady flow of funds and that the government's disinvestment policy is successful. But that being said, I do see this as a very good opportunity for investors, and I think the market sentiment also conveys the same.
Right. I think you very well explained in that disinvestment, because disinvestment was in air apparently, and there was like such hoots when government initiated Air India ka disinvestment, and there was a PIL filed. I remember. I don't know for what reason, but like comments aside for that. But ma'am, since we were talking about disinvestment, and I think you rightly touched upon that, because I recently heard that Tesla has now it has withdrawn its plan to set up a plan because of the tax slab rates in India. So, ma'am, since we are in this sector, we have seen, and of very recently, foreign investors are in a bit of dilemma when they think of investing in India. And since we have especially things like FPI, VRR for that matter, where SEBI regulations are in place, and SEBI regulations are stringent, very stringent, be it for the national investors or the international investors. So, do you think that there could be certain regulations in with regards to FPI and FPI VRR that could be touched upon or maybe amended, so that the foreign investors think that yes, this is a place where we can go ahead and invest to avoid the dilemma?
So I think I don't see a problem with FPI or FPI VRR in particular, and I'll tell you why. Because FPI investments in general have been very popular among investors. It's not, and even when I was, working, doing my transactional practice, we didn't really come across a lot of hurdles in terms of investors wanting to go through this route. And in fact, just recently, I think the FPI VRR corp limit was increased from $200,000 to, sorry, 200 $2 lakh million or 2 lakh something, it was increased to $250 billion. So that way it's a good indicator, and it shows that the route has been very successful. But I think the reason why, if you're reading in newspapers these days, that a lot of FPI investors are pulling their investments out, and the sentiment recently has not been very positive. The reason for that would be largely the economy and the economic conditions at large. So I don't see a problem with India or the Indian framework on FPI or FPI VRR in particular, but I think in general, because of the global crisis and because of the interest rates and the Russia-Ukraine crisis and the oil and gas prices and everything else that's going on in the world, the market sentiment has been a little poor. But I'm hopeful and I'm optimistic that with time things will start going back up again. In fact, I think the VRR is a very innovative route because I'm not an expert on the laws of other countries, but I haven't come across any framework such as the VRR where they're trying to encourage foreign portfolio investors to stay in the Indian market, and they're offering such relaxations which are not otherwise applicable to FPI investors.
Ma'am, so I had two questions. I had one question, but the FPI conversation really piqued my interest specifically. So this is not from this sector specifically, but I witnessed how whenever an FPI also comes in, they through their share and somehow like they try to still influence the board decisions and the functioning of the company, right? Or there is an example of the Invesco situation wherein they tried to call an extraordinary general meeting and affect various changes into it. So within that, they were unsuccessful, and they could tell how the Indian framework is trying to stop foreign influence per se. But if you could touch upon that.
So the thing is that any foreign investor, if it's investing in a company, it deserves some say, right? Especially if it's investing in the equity of a company. Equity by itself means that it should come with voting rights. It should come with the right to participate in the decision making of the company. So I don't think foreign investors are wrong in wanting a say in the functioning or governance of a company. The reason why I said that FPI investors don't usually have the say is because their stake is very limited. They only own a certain percentage of the share capital of the company, which is up to 10%. The maximum is 10%, whereas in case of FDI, that's much higher. Much higher is permitted. So in that sense, FPI investors don't usually exercise that say, or their say does not carry as much relevance because their shareholding is nominal. But that doesn't mean that they should not have that say if they want to exercise that right. Even a person who holds one equity share in a company has a right to vote on it and to participate in the decision making of the company. In case of the Invesco dispute, I mean, everyone has different views about it. But I don't think that the Indian law is in any way trying to prevent the investor from having his or her say. Of course, there might be manipulation by the promoters or by the family in different cases. But in any case, I don't think the law itself is trying to prohibit anyone. In fact, if you see, ultimately the position taken by the courts was that the EGM should be called, or the EGM is permitted. And just because the promoter family took the view that the EGM notice was invalid does not mean that it was actually invalid, because they were saying that the notice is invalid because certain permissions are required, let's say from the broadcasting ministry, or independent. If they fire the managing director, then it will be in violation of the law that requires a managing director. And the court said that, look, these are all conditionalities. These are not things which will make a resolution itself invalid. These are just things which need to be done in order to give effect to the resolution. But ultimately, the court did take a pro-investor stance, and the court did opine that that the investor had a right to call the EGM. It's obviously later that because of maybe some commercial reasons or other reasons or whatever the reasons might be, that the investor itself decided to not call the EGM and instead is now, as I understand, planning to sell its stake, part of which has already been sold. But the laws per se, I don't think prevent an investor from having a say in the affairs of the company.
That's a very well nuanced answer. I wrote a paper on this, so I always wanted to get a lawyer's perspective who's actually practicing in the field regarding this. So it's a very great say regarding this. And finally, I had a question regarding the government disinvestment. It feels like an eternity since we touched upon that. But so we did talk about how construction development also includes infrastructure stuff such as roads and bridges. So specifically regarding those, they in particular are a very important asset to the public, right? Public use them daily, and
Yes.
privatization of such assets, especially when we've seen the development of highways and all that, wherein the tolls that are being charged are exceptionally high due to the private say in it. So how we can tackle that when it is something that is as important as a subject of transportation, where people are able to like travel, and us pe bhi, like there are such high charges. So is disinvestment in this specific area a good idea?
So I think again the views will differ from person to person, but I feel like this investment may be a good idea because more efficient. It's necessary to conduct these operations more efficiently, and many a times even a lot of inflow or more money is required to carry out these activities. So in that sense, it might be a good idea to privatize, but what you said is also a valid concern that the prices or the tolls or the other charges may be extremely high and probably unreasonably so. So in that case, it might make sense for, let's say, thinking from a lawyer's point of view, to include conditions in the investment agreements or in the partnership agreement saying that this is what the tolls or the charges can be, and they should not be higher than this because this is something that we're doing in public interest, and public interest envisages that these facilities should be available to the public at reasonable charges. So probably conditions like those could form part of the documentation or could be prescribed under laws.
That's a very, I don't know, I'd say it's a great understanding of the same, the issue where public interest needs to be put first. Uh, Finally, I wanted to ask how the experience in the sector has assisted you as a lawyer, the development of yourself as a lawyer, and how you made the decision to finally, go ahead and pursue an LLM and, continue upon further studies before basically pausing your career and then resuming it at a later stage. So how did you arrive upon that decision?
So actually, working in this sector and working on deals and transactions in general was very enriching, extremely enriching. And it obviously happened on the job itself, where we were able to work on real transactions, see how things work, and apply them in practice. So that was very exciting. I worked with the general corporate team at a firm, so we worked across sectors. Construction and development was one of the sectors, but there were other sectors such as insurance, hospitality, pharmaceuticals that I also got the opportunity to work on. So it was very enriching, and there was a lot to learn. And I think in the process of learning that, what I realized was that our framework is not foolproof. There are things which can be different. There are things which can be taken another look at. There are things which can be maybe more critically analyzed and then policies framed accordingly. So I think it was just that sort of realization that there is more to be done, and also a realization from within that I'll probably like doing things like that because I always had a research oriented aptitude, and I thought that this is something which will interest me. So that is what led me to transition from a law firm role to apply for an LLM and see what else lies over there. And an LLM, I think, will be very fruitful in that sense because it will allow me to learn not just about our framework, but about the frameworks of different countries. And it will also, I hope, help me in developing my critical reasoning and analysis skills so that I'm able to critique and I'm able to form my own opinions a lot better. And ultimately, I hope to either transition to academia or research or policy making in that sense. But of course, the good fortune and my the ability to have worked in the sector for real on real transactions was the foundation for what I intend to do in the future.
We sincerely hope the comparative experience that an LLM gives you helps out in you and your policy and research oriented endeavors. But beyond this, we do not really have any questions left. So we would like to thank you for making time to be here It was a pleasure to have a conversation with you regarding this sector. And if you would like to close it off.
Sure. This was my pleasure to be here. Thank you so much for having me here and for asking such fruitful and such engaging questions. This is a very innovative initiative. I haven't seen many podcasts specially devoted to a space as niche as this. So I wish you all the very best, and I hope that this initiative and this organization goes from length to length.
Thank you so much.
Thank you very much, ma'am. Thank you.
Thank you.